What happens if a will pours everything into a trust and I am not sure whether I was included? In North Carolina, a pour-over will usually sends probate assets to the trustee of a trust. The will may not name every final beneficiary. The trust document controls who receives the property, including any valid amendments to that trust. So you are not automatically a beneficiary just because you cared for the person, lived in a house under an informal arrangement, helped with property, or heard an oral promise about a car, truck, or other item. The first step is to get the probated will from the estate file and identify the executor and trustee. Then make a written request to the trustee for the trust provisions or information needed to confirm whether you are named, included in a beneficiary class, or excluded. If the assets were titled in the deceased person's individual name, they usually start in the probate estate and may later pour into the trust. If they were already titled to the trustee handles them directly. Watch the timing. The executor's inventory is generally due within 3 months after qualification. If you need to challenge the will itself, the deadline can be as long as 3 years after probate in common form, but some objections and appeals have much shorter deadlines. If the trustee will not provide information and you believe you have beneficiary rights, you may need to ask the court for instructions, an accounting, or other trust relief.